Oh, he thinks it's funny that I'm,
Just
it's
I don't think anything's funny about it, sir. I'm just telling you, you weren't answering my question.
This case opens with immediate tension, and that's not accidental. From the very first seconds, Judge Simpson is already pushing back against what he perceives as a lack of seriousness from the defendant. In court, tone matters just as much as words, and when a judge feels disrespected or dismissed, that perception can follow a defendant through every ruling that comes next. What we're watching here is not just a plea hearing, it's a credibility test. Wayne Eagleston isn't only being evaluated on the facts of the charge, but on whether the court believes he understands the gravity of the situation. Attempted unlawful use of a motor vehicle might sound minor to some viewers, but legally, it's a misdemeanor that carries real consequences, up to a year in jail, fines, court costs, and potential license suspension. Judges take vehicle-related offenses seriously because of the risk to public safety. When Judge Simpson clarifies that he is not the sentencing judge and cannot bind the next judge to any agreement, that's a critical warning. Plea agreements are not guarantees. They are recommendations. This moment sets the tone for everything that follows. The court is calm, methodical, but clearly alert. The question for viewers is simple. Does Wayne fully grasp that this isn't a casual process, or is he treating it like paperwork? That distinction often determines how much leniency a defendant ultimately receives.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Eggleston.
That's just me. You're going to get sentenced by Judge Freshour and not Simpson. Thank you, Mr. Allen.
Your name, sir?
Wayne Eggleston.
All right. I have before me a plea form that indicates the defendant is going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle, 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. I guess that's SA is sentence agreement.
That's correct, Your Honor.
Sentence agreement to 1 year in jail, which this court cannot bind the sentencing judge to, although I understand it's your agreement. And no delayed or deferred. Again, this court is not binding the sentencing judge to that.
Thank you.
That's correct, Your Honor.
Let's have him sworn.
Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
State your name.
Wayne Eggleston.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle.
Correct.
All right, that's a misdemeanor punishable by up to 1 year incarceration and a $750 fine plus court costs, as well as license suspensions by the Secretary of State. You understand that?
Yes.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Correct.
All right. Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct, sir?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
This exchange is far more serious than it initially sounds. When probation enters the conversation, everything changes. Being on probation means you're already under court supervision, and any new offense, even one from the same incident, can create cascading consequences across multiple jurisdictions. Wayne's confusion here is dangerous. Same day, same vehicle, different counties, different charges. That's not a loophole. That's a legal minefield. Judge Simpson is carefully untangling whether this offense occurred while Wayne was already under supervision. If it had, that could trigger probation violations, additional penalties, or even immediate custody. The fact that Wayne seems unsure doesn't help his position. Judges expect clarity and accountability, not uncertainty. This is also a reminder of how jurisdiction works. Counties don't merge cases just because the conduct overlaps. Each county has authority over offenses committed within its borders. Same act, same vehicle, same accident. But legally, they can still be treated as separate matters. Here's the engagement question for viewers. Do you think the justice system should consolidate cases like this when they stem from one incident? Or is it fair for each county to prosecute independently?
All right. Which one?
Probation.
All right. Were you on probation at the time of this offense?
No,
You sure? You don't know?
it's the same offense in a different county. Same day, same offense. Different charge.
All right, so you're on probation in another county
For this.
that happened after or for this, but the events occurred in a different county.
Yep.
Okay. Then I don't think you need to.
Another different charge, different county, same case.
Same possession of the same vehicle in a different county.
Yep. Same vehicle, same accident. Yep. Different county.
All right.
Add another charge to it. Yep.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced?
No.
You're doing this voluntarily
Correct.
of your own free will
Yes.
because you believe that you are indeed guilty?
Yes.
July 23rd, 2023, at the location of 9575 Austin Road, Bridgewater Township, Washington County, State of Michigan. What'd you do that makes you think that you're guilty?
I used one of the work trucks and got in an accident.
This is the factual core of the plea, and it's more nuanced than it sounds. Wayne admits using a work vehicle, but initially frames it around the accident, not the permission. Judge Simpson doesn't let that slide. The legal issue isn't whether an accident happened. It's whether Wayne had authorization to use the truck for that purpose. Permission for work does not equal permission for personal use, and that distinction is critical in vehicle-related offenses. Watch how the judge narrows the question step by step. This is classic judicial technique. Strip away ambiguity, eliminate qualifiers, and force a clear admission. When Wayne finally agrees he took the vehicle for non-work purposes without permission, the elements of the offense are satisfied. That's what allows the court to accept the plea. This moment also explains why judges interrupt or redirect defendants. It's not hostility, it's precision. Courts cannot accept vague admissions. They need clean facts on the Wayne record. Ask yourself, if Wayne had continued hedging, would the court have rejected the plea? And how often do defendants unknowingly sabotage themselves by trying to soften the truth?
Did you have permission to take that truck for that purpose?
Not to get in an accident, no.
Well, did you have permission to take the truck at all?
Depending on the circumstance, but no, let's say no. Let's go with no.
You had permission to take the truck for work purposes, correct?
Yes.
And you took the truck for non-work purposes.
Correct. There
And
you
you
go.
didn't have permission, is that correct?
Correct.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes.
Whoa, not the.
Well, he thinks it's funny that I'm, it's,
I don't think anything's funny about it, sir. I'm just telling you, you weren't answering my question.
I used the truck for non-work purposes, so I didn't have permission at the time that I took it. Correct.
I'm sad. Defense is satisfied. Thank you, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
October 29th at 9 a.m. before Judge Fresh Hour.
October 29, 2024, 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you.
Thank you, Your Honor.
Pam Mackey on behalf of Mrs. Mopkin, who's approaching.
No, look this way, ma'am. Come on up. Your name?
Latricia Mopkin.
Thank you.
Your Honor, requesting to set this matter for preliminary examination. May I just bond, Your Honor?
You may.
Ms. Latricia, she works at U of M as a housekeeper. Currently, she's on non-paid leave. However, that's temporary and she could permanently lose her job there. She has 4 kids and one of them, Ms. Latricia is the sole provider for her kids. Her family is here today in court as well, and she has a place to stay with them upon release. So we're asking for Ms. Latricia to be released, and she is okay with complying with GPS tether or any other conditions the court finds necessary.
Responsible.
Your Honor, at this point, I'm going to object. This is an extremely serious case in which the victim was attacked.
The emotional temperature shifts dramatically here. We move from a vehicle offense to allegations involving a hammer, a stabbing, and severe bodily harm. The prosecutor's objection is grounded in risk assessment. Bond decisions aren't about guilt, they're about safety. When violence and weapons are alleged, courts become far more cautious. Defense raises self-defense, but Judge Simpson immediately probes the claim. Self-defense isn't a label, it's a legal standard. Was there an imminent threat? Was there a weapon? Was the response proportional? Without evidence that the alleged victim possessed a weapon, the argument weakens significantly at this stage. The judge's denial isn't a moral judgment. It's procedural. Preliminary examination comes first. Facts will be tested later. For now, the court prioritizes control and order. This is a key viewer moment. Should bond decisions err on the side of caution in violent cases, or should courts give more weight to personal circumstances like employment and family?
With the hammer in which he was hit in the head several times with that hammer, there was a struggle then for that hammer, and then during that struggle, he was then stabbed in his stomach. So given the severity of this case and the injuries that he sustained, I'm gonna object at this time to any modification of bond.
And Your Honor, we are presenting this case as a self-defense, and Ms. Latricia would not be staying at that address upon release. She would be staying with her daughters, looking after her.
I mean, typically the self-defense isn't, I mean, are you indicating that the alleged victim possessed some weapon at some point?
I believe there was some form of altercation.
Well, an altercation is one thing. Are you saying that a weapon was possessed? Because
No.
that might factor into the court's decision, but if that's not what's being said, then I'm not sure that true self-defense is going to apply in any event, although I'm not trying to make that analysis.
There was no actual weapon.
Do this. There's the allegation that there are two weapons that would be used
Yeah,
by
I
this
haven't-
defendant.
He did have a knife, Your Honor.
Okay, then you can certainly address that even, while I'll factor that in, I still don't think bond would be appropriate or a reduction in bond would be appropriate in this case. I'm going to deny your request. Certainly you may raise that after the preliminary examination on the 20th before Judge Freshow.
Thank you, Your Honor.
Thank you.
Thank you.
Guys want to walk around?
Young lady? No, come here. Come here. Oh, boy. Get her, Mr. Allen. Who is that? Who was that?
Family of the last client, I believe, Your Honor. To the full moon.
What?
To the full moon.
No, people are usually better. They're not back yet. There's a problem. You got a problem probably in the hallway, guys. I'm sure security sees it. Can you just call and make sure that they're how many more do I have? This is it.
So, custody in custody. 557. And you got that over there.
Be careful.
I want to look. Oh,
Should have given bond.
Until the case.
yes, I'm so sorry. Yes, so that matter has come back. Apparently, so I looked up at GIS, but yesterday, the company's office called. They don't know. On next week. So.
Right, I'm gonna step off. if she brings them in, just throw her in the box over here or cuff her, put her wherever. Lady, what's your name?
Sequoia Jones.
What?
Sequoia Jones.
Why were you causing a disruption in the court and then
I
didn't
was
come
talking
back?
to my mom lawyer.
This is where courtroom authority becomes visible. Disruptions are not minor infractions. They strike at the core of judicial control. Judge Simpson's response is firm but measured. He's not reacting emotionally, he's restoring order. When someone ignores direct instructions from the bench, the court has limited options, and custody is one of them. Sequoia Jones' explanation introduces empathy into the equation. Emotional overload, family trauma, and shock are real, but they don't override courtroom rules. The judge acknowledges her explanation without excusing the behavior. That balance is intentional. Courts must maintain decorum while still recognizing human emotion. This exchange also serves as a warning to everyone in the room. Courtrooms are not public forums. Speaking out of turn has consequences, regardless of intent. Engagement question: do you think Judge Simpson handled this with appropriate balance? Or should emotional distress carry more weight in moments like this?
And he stood up. I wasn't talking to him. I didn't say nothing to him. I was talking.
Why didn't you then stop when I told you to stop?
I apologize.
That doesn't work that way.
Your Honor,
You want to be represented by counsel, ma'am, because you disrupted these entire proceedings. You want an attorney?
Yeah.
The PD can handle this, I think. She can go back into custody. I'm gonna take a brief recess and then I'll bring her back out. Just in reference to this case, we'll call it in regard to the Mopkin matter. The defendant does not need to be present and is not present. I think Joy was.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of the respondent, defendant. I don't.
Yeah, yes, she would be responding. Your name, ma'am?
Sequoia Jones.
Ma'am, you know why I held you?
Yes.
Tell me what your thought is on why I did.
Because I disrupted your courtroom.
Yeah, you disrupted the courtroom, and then when I asked you to come back, try to figure out what was going on with you, you just kept continuing to walk. Why'd you do that?
My mind was like blank. That's my first time seeing my mom since, and it was just like a lot. It was too much.
This is one of the most human moments in the entire courtroom sequence. Sequoia isn't denying what she did. She's explaining what overwhelmed her. And Judge Simpson listens. That's important. Courts don't operate in a vacuum. Judges understand emotion, stress, and trauma. But what matters is how those emotions are handled inside the courtroom. The judge draws a firm line here. Explanations are allowed, disruptions are not. What stands out is Sequoia taking accountability. She doesn't blame the court, the lawyers, or the system. She admits she was wrong. That acknowledgement is a turning point. Judges weigh remorse heavily, especially when deciding whether to escalate punishment or offer a second chance. This moment also reinforces a broader lesson. Court is not the place to intervene emotionally, even when the case involves family. Attorneys speak for clients. Anything outside that structure can backfire quickly. Audience question: if you were overwhelmed like this in court, would you have been able to stay silent, or would emotion have taken over?
This is my first time seeing my mom since this incident happened. And I was trying to ask the lawyer something. I was so focused on her answering my question. I couldn't even really hear anything else. I was too upset. But I'm not using that as an excuse. I take accountability. I was wrong for that. But
Your mom's coming back in a week or two, right?
That's correct, Your Honor.
Huh?
That's correct, Your Honor.
So is it that you can't, in seeing all of that, can't keep yourself composed in the courtroom?
no, I thought it was an understanding before my mom got up here about mentioning her injuries, and nothing was mentioned about that.
Okay.
And that's what I was asking
Can I
her.
just say this?
Oh, okay.
You need to let the attorneys do their job. Okay?
Mhm.
You have an issue to the extent that they'll even talk to you. If you have an issue with that, then you deal with that outside of this courtroom. So should I banish you from coming into this courtroom again?
No,
You think you can conduct yourself?
yeah, yes,
Young lady, I'm gonna give you another chance. If you come back in here and act the way you did, I'm gonna guarantee you this. You'll be locked up like you are now, but I'm not letting you out. Are we clear?
yeah. I have no problem with that. I'm not a disrespectful person.
You're not what?
I said I have no problem with that. I'm not a disrespectful person. I wasn't
Oh,
raised
you
that way.
were today.
Judge Simpson's response here is blunt and intentional. He doesn't accept vague character claims like, "I'm not disrespectful." Courts judge actions, not self-descriptions. And when he says she was disrespectful, not only to whoever you were talking to, but also to me, that's a reminder of courtroom hierarchy. The judge represents the authority of the court itself. Disrespect to the bench is treated seriously because it undermines the process. What follows is a conditional warning, not a punishment. Another chance is granted, but with clearly stated consequences. This is judicial discretion in action. The court could have imposed sanctions or kept her in custody longer. Instead, Judge Simpson chooses deterrence over escalation. This is a critical retention moment for viewers because it shows how quickly situations can shift in court. From restraint to consequences to mercy, all within minutes. Question for viewers: do you think warnings like this are effective, or do courts need to be stricter to maintain order?
I was today, but I'm not.
Not only
every
to
day.
whoever you were talking to, but also to me, and I hadn't done anything to you. Right?
Mhm.
So just check yourself next time before you come in here. All right, we can release you. Let her go.
Thank you.
Thank you. Court is staying in recess, and I guess we'll come back and do our 2 o'clock block and on.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Bucko, who stands to my right. Your name for the record, sir?
Aaron Bucko.
Thank you, Your Honor. I am ready to address the warrant and the progress report if the court would like to hear about that first.
Yes, they would.
Thank you, Your Honor. As the court is aware, there was a progress report sent out. It was around Christmas, I believe it was the 23rd of December, that there had been some missed and late flows into the sober link. And at that time, there was a warrant issued. At that time, I did discuss it with Mr. Bucko.
Go ahead.
Oh, sorry, Your Honor. And at that time, I, of course, discussed the importance with Mr. Bucko of blowing on time. He stated to me at that time, of course, he stayed in constant contact with me throughout this case. He stated at that time that he has not consumed alcohol. He does take this matter very seriously, and largely due to those late or missed tests has to do with work. He does have full-time employment. He works in a warehouse. He usually works from 6 in the morning to 5:30 in the evening. He states to me he works this schedule Monday through Friday. Once in a while, he'll even start a little early, working at 5 a.m. Again, he does this Monday through Friday, full time. He works at a replenishments, so often sometimes he misses the sober link blows or they come late. I did receive also a letter or an email.
He's got a 3-hour window, so he's up for 3 hours.
Are you up for 3 hours at a time, Mr. Bucko?
Now we move into a completely different type of courtroom issue: compliance monitoring. SoberLink is not optional, it's a court order. Missed or late tests are often treated as presumed positives because the system is built around accountability, not convenience. Judge Simpson zeroes in on the pattern, not the excuses. Work schedules may explain 1 or 2 issues, but repeated failures raise red flags. This is where many defendants misunderstand probation conditions. The responsibility is proactive compliance. If the window is 3 hours, the safest move is to test immediately, not wait until work or life interferes. Judges expect defendants to structure their lives around court orders, not the other way around. From a legal standpoint, the judge is evaluating trust. Can this person follow simple, repetitive instructions? If not, more restrictive supervision becomes justified. Engagement question: should courts adapt monitoring requirements to real-world work schedules? Or is strict compliance the only way to ensure accountability?
Could be, it's different every time.
And
Go ahead.
I did discuss that with him and asking about if we could request the court to switch to a scram tether. He is asking at this time if the court would consider recalling the warrant and putting him on a scram tether. He did complete an alcohol screening and assessment through Ron Schwartz, which I just received yesterday afternoon and provided to Mr. Siller yesterday afternoon. That being said, there is a potential resolution in the works. So I guess I'll comment further on that in a little bit. But I also received a letter in support via email from his mother, who one of the quotes in the letter was that she's not a mother who says that her child will do no wrong, but she did want to say that although she acknowledged this was a serious charge, but acknowledged that Mr. Bucko did take this seriously. And to her knowledge, she does not believe him to be drinking and does believe that a lot of this was due to the scheduling and the blows. I believe that Mr. Bucko will be able to show the court that he is abstaining from alcohol and is taking this matter seriously if he is able to be placed on a scram tether so that he can show that he has not been drinking. I do acknowledge as well that since that warrant was issued in end of December, that there was only one, based on the progress report I just received the other day, there was one further late blow. It appears that it was a 37-minute late blow. I'm not.
Yeah, but that is not, does not paint an accurate picture. Because what we had was, he had numerous late blows prior to the time prior to December 8th. We didn't just issue the warrant on him. We sent an order telling him he needs to comply with it, or the court was going to have to take further action.
That is, yes, Your Honor. Yes, Your Honor.
So,
and
go ahead.
Oh, sorry, Your Honor. And I did remind Mr. Bucko of that. And frankly, there is no getting around the fact that he did blow late, and that was a court order to blow within those time windows. And I got kind of serious with him and told him that he needs to comply, and that there was that second chance given with the order to comply previously. Then there was the additional progress report that was submitted the end of December. Then the warrant. Since then, there has only been one late blow. Mr. Bucko does maintain he has abstained from alcohol. I'm not in receipt of any reports that he did test positive at any time for alcohol. Quite frankly, I'm asking if the court would give him yet another chance and put him on a scram tether so that we alleviate the whole window time. If he has any sip of alcohol at any time, day or night, of course it would register. That would be immediate bond violation, and he'd know exactly where he would go immediately. He is asking for the court to give him another chance. He again maintains he's been staying abstinent, and it is our intention for him to hopefully start AA soon so that he can take advantage of a potential offer in the works. To that end, Your Honor, as to the pretrial, we were going to be requesting a brief adjournment. But as to the warrant, Your Honor, I'm respectfully requesting if the court would consider canceling the warrant.
Said it like 8 times. I get what you're asking. Anything from the people?
Oh, and it's the court's discretion, Your Honor. The late testing is obviously extensive.
Yes. All of these couldn't have been related to work, could they?
I'm assuming that, yeah, they probably were.
So let me ask you this. There's a 3-hour window. Why aren't you blowing at the beginning of that 3-hour window?
I try to, whenever, like, in between those 3 hours, I try to do it like literally just whenever I can or whenever I get a chance. And sometimes if I am like at work, it just.
Because when I'm looking at this, I'm going to tell you what this tells me, man. That you're not taking this seriously.
This is one of the most revealing judicial statements in the entire proceeding. Judge Simpson isn't accusing Mr. Bucko of drinking. He's accusing him of complacency. And in probation cases, that distinction matters. Courts care just as much about attitude as outcomes. Missed blows signal indifference, even if no alcohol is detected. The judge explains perception, which is critical. In court, how things look can be just as important as what actually happened. Judges must make decisions based on patterns, not promises. When orders are ignored, even unintentionally, it erodes confidence. This is also where the stakes become explicit. Jail is not theoretical. It's on the table. The judge makes that clear to cut through rationalizations. Viewer question: do you think judges should factor intent more heavily? Or is perception the unavoidable reality of court supervision?
I really am.
Because, well, but hold it. You have to understand how it looks to it. Certainly looks to me, because I sent you an order that you had to blow, and then I don't go a month and all of a sudden you just miss.
I understand.
So do you want to go to jail? I mean, because we can just cut to the chase. I can just send you down.
No, Your Honor.
Here with you.
My mom, my dad, and my girlfriend.
Okay, there's dad back there. Mom, I think I saw them moving to try to get closer. Did you get yourself enrolled in the GED program?
I did, yeah. Classes were starting in January, and then I turned, because I just turned 22, and they told I wasn't eligible because I was over the age of 21. So I'm actively, me and my mom are actively looking for a class. She can vouch for me on that, like a free one, because I was enrolled and turned 22.
What?
Because I turned 22, I wasn't eligible. I have the text from them.
So where did you enroll? You enrolled at?
Success Virtual Learning, I believe. It was online.
Oh, okay. And so then they said, once you hit the age of majority, you're not eligible.
Yeah, because I enrolled right before my birthday, because my birthday was December 23rd. And so once I turned 22, I wasn't like eligible to do the GED class anymore, because it was like a 21 age limit, I guess, that they had. But I am actively looking for.
Sometimes you don't take what you got to do in life seriously, do you?
Sometimes I will admit, no. But this, I promise you, I was truly trying my best. I have not consumed any alcohol. Like when the warrant was issued, I like asked if they could send me in for like a blood test or like whatever to like show that I haven't consumed.
Okay, but here's what you need to understand. I'm worried about your consuming alcohol.
This section is a masterclass in judicial explanation. Judge Simpson clarifies that missed SoberLink tests can legally be treated as positive results. That's not arbitrary. It's built into the logic of monitoring systems. Otherwise, avoidance would be easy. This is why compliance is non-negotiable. The judge also ties this back to Mr. Bucko's blood alcohol level, grounding concern in public safety rather than punishment. High BAC cases aren't just violations, they're indicators of risk. The court isn't trying to catch someone slipping up, it's trying to prevent tragedy. What's powerful here is the judge's tone. Firm, disappointed, but still invested. This isn't a lecture for the record. It's an attempt to redirect a young defendant before consequences become irreversible. Audience engagement. Should courts intervene aggressively early, or wait until violations escalate further?
Because you have to understand, you were a .223 and were able to operate a motor vehicle, which leads me to believe you were drinking quite a bit. And sometimes it's hard for people just to stop. But what I'm talking about is the missing of blows. Yes, I can't understand that. I get every once in a while something happens, and that's typically what that order was designed for. When I saw this one, we sent it, but I said, I hope he gets himself in the right place so that I don't have to send it. And expecting, quite frankly, after I sent out the order that I wasn't that this is not what I would be dealing. You need to understand that when somebody misses a blow and I put you on a SoberLink and you miss a blow, I can consider that a positive test. You get that?
I understand.
When I'm talking about taking things seriously, you're telling me you're taking this seriously, but the whole discussion we had about you and graduating and all of that, and me listening to you got to take more of this seriously and understand you got to do what you got to do. You hear me?
I understand. Yes, I agree.
Mom, you want him back?
Absolutely. And I mean, as far as the missing, he doesn't have license, he can't drive himself to work. Some of his rides are only able to pick him up at 4 o'clock in the morning. I work from 5:30 till, so life is a little difficult with the rides. It's getting worked out. He is telling the truth. He did turn 22 on the 23rd.
No, I believe him.
We are looking for a program where either
I got it.
his father can help out with getting him back and forth. What his girlfriend's willing to help out, I'm willing to help out.
Dad, you want him back? Yeah. Listen, probably should ask the girlfriend. You want him back? Because if you don't want him back, if you tell me no, then I'll put him away. You do? He had to breathe hard because he didn't know what she was going to say. Look, young man, I know you're trying, but you got all these people supporting you. They're all here. There is not a reason for you to fail on this stuff. It's the stuff you're messing up on. It's the easy stuff, right?
Yeah.
I'm gonna say it again. You are 0.223. I am just fortunate that I get to yell at you. Because at that level, you could have killed yourself.
He can actually tell you that he lost his brother-in-law for the same blood alcohol content. I don't feel like last year, a year ago.
Brother-in-law, you lost somebody? So you really know how lucky you are, right?
This is the emotional apex of the hearing. The mention of a lost brother-in-law reframes everything. Suddenly, this isn't about missed tests or paperwork, it's about life and death. Judges rarely personalize like this unless they believe it might break through denial. Judge Simpson isn't minimizing the seriousness of the offense, he's contextualizing it. At a BAC of 0.223, survival itself is not guaranteed. The judge makes it clear, yelling is a privilege here because the alternative could have been a funeral. This moment humanizes the bench. It shows why judges sometimes speak bluntly. They've seen the outcomes defendants haven't yet. Viewer question: do you think moments like this actually change behavior, or do they fade once court is over?
All right, so young man, let's do this. Let's just try to start again. I'm not gonna lock you up. Okay? Let's just sort of reset this. Let's try to get you back on track. You're 22. Let's just get you back on track and let you try to do some great things in this world. How about that?
Thank you, Your Honor.
All right, so what I'm gonna do, I'm gonna adjourn your case to the 4th, February 4th, 2026. I want to see some progress in terms of get yourself an edgy, okay? And what I'm going to order, we'll do an order now. I'm going to order that you report over to the Department of Community Corrections. Best to do it before you leave here. You have your sober link with you?
Yeah.
Okay. So you have to turn that in. I'm going to put you on the scram tether. I'm going to give you a shot. And I'm going to tell you right now, most people with this blood alcohol level that don't comply with sober link, I don't even trust them on the scram.
Thank you, Your Honor.
And I usually just lock them up and that's it. I'm gonna give you a shot.
Thank you.
You gonna let me down?
No,
You better not.
I will not.
You know how I am. I get cranky.
You
Right?
have my word. Thank you very much.
You're welcome. All right, we'll see you on the 4th.
All right.
Thank you folks for coming down and supporting him.
Maybe he's right.
You're welcome. And young man, I mean it. Give your girlfriend a hug, because if she had said no, you would have been gone. All right? Take care, guys.
This is the resolution and the warning. Judge Simpson grants another chance. switches monitoring to a scram tether, and makes expectations unmistakably clear. This is not leniency, it's conditional trust. Scram is stricter, constant, and unforgiving. Any alcohol consumption will be immediately detected. The judge openly states that most people with this history wouldn't even get this opportunity. That transparency matters. It signals both the seriousness of the situation and the rarity of the second chance being offered. Professionally, this case highlights the court's balancing act: public safety, accountability, rehabilitation, and proportional response. Judge Simpson doesn't excuse behavior, but he still believes intervention can work. This courtroom session shows how quickly legal consequences can escalate or be redirected based on accountability, honesty, and effort. From plea admissions to bond denials to probation warnings, every decision here reinforces one truth: courts reward responsibility and punish disregard. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.